Hello and welcome to the Genuine Learning Blog. My name is Melissa Galasso and I am really excited to be here to give you an update on yesterday's FASB meeting. So FASB met to discuss just one proposal, which was the Leases under Common Control proposal. This is obviously a very important standard because this will impact a lot of private companies, and I am happy to report that the FASB did affirm the proposal. So we're just going to go over a couple of the changes that happened as a result. So this proposal was issued back in November of 2022 and comments were due on January 15th. So a relatively short period of time to get all of those things kind of wrapped up. And 1 month after we had the comment letter due date, the FASB met to discuss the comment letters. They received 29 comment letters from the proposal. Honestly, I thought there would be a lot more. I will say it was a pretty mixed bag in terms of responses. Some of it was very favorable. In fact, the majority of it was favorable, but there were some concerns noted in the process. At the end, after they had voted out both issue 1 and issue 2, Hillary Salo, who is the technical director for the FASB, indicated that the expected issuance date won't be until the end of March 2023. So just as a little bit of heads up. So why did they have this proposal to begin with? The feedback that they had received during, private company town halls, especially at the Engage conference, the private company council also providing similar feedback. It was that private companies had a lot of concern around the operability of the term legally enforceable when dealing with related parties. For many of these organizations, they are, related organizations where there's not really good, descriptions of the terms and conditions. A lot of it can be oral, and trying to decide if something was legally enforceable would require a consult, and obviously that can be very costly. And so as a result, they decided to bring this back and take a look specifically at common control arrangements. So issue number 1 specifically addresses private companies, and this was unanimous. It was a 7-0 vote. Every single board member voted in favor of it, and this is for private companies and nonprofits without conduit debt, right? So those with conduit debt fell under the public definition for leases, and so they can apply this practical expedient, which allows them to use, and here's the key element, written terms and conditions of their leases to determine whether a lease exists, and if it does, the classification and accounting. So if the related parties, these common control entities, sit down and write that it is a 1-year lease and there are either no renewal options or only through mutual options of renewal, then you have a lease less than 1 year. And that's what you go with. You don't have to look to see whether there are implied options. You don't have to look at all of the legal enforceability considerations here. You just look at the written terms and conditions. Now, if you don't put it in writing, then you go back to the traditional guidance and you would fall under topic 842 and you would have to use the legally enforceable terms. So you'd have to say, okay, if it's not in writing, let's look at what would be enforceable under our law. Is there any laws that indicate that it has to be in writing? If it doesn't have to be in writing, what is precedent that has been set in this area? And so they're kind of encouraging private companies and nonprofits without conduit debt to put it in writing, because if they do, it can be on an arrangement by arrangement basis, allow entities to use the written terms and conditions without having to consider reading into the terms and conditions. Now, they are going to give a little bit of clarification about what does it mean to be written terms and conditions, and that's probably going to likely be in the basis, but we're going to have to wait and see. We don't have a copy of the draft. We just had a copy of the information that was provided in the agenda handout. They also allowed, because again, we are after the effective date of leases for most private entities that have a calendar year end. And so they would still be able to apply this practical expedient to currently unwritten terms, so long as when they transition to 842, they put it in writing. So even though the lease is technically potentially over, they could obviously still write that lease for the prior year in order to meet the requirement of those written terms. Now, as I mentioned, there were 3 staff recommendations that were approved related to the description of the form and content, the verbiage in the transition guidance, and what happens when you have a change. So in both of those, in all 3 of those scenarios, those were affirmatively voted on unanimously. And so we will see some modifications to what was in the exposure draft when we get a final ASU in March of 2023. The second issue is a little bit more contentious. This was actually a 4-3 vote. It is the same vote that came out of the exposure draft. So the same 3 people who dissented in the exposure draft dissented in the final standard as well. And this is around leasehold improvement amortization. Currently, you amortize over the shorter of the useful life or the lease term these leasehold improvements. Now, as was pointed out by multiple board members, it doesn't say you amortize to 0 because theoretically there could be residual value at the end of a particular lease, and so there's nothing that says you have to amortize something to 0. And so what this is going to change, instead of amortizing it over the lease term, it would allow you to amortize it over the useful life, because again, this is common control arrangements. And so what would happen is at the end of the lease, it's going to revert back to the common control lessor. And so what they decided to do was to allow entities to amortize it over the useful life. Now, I will note that we bolded and made purple useful life. In the exposure draft, they had used the term economic life, but that's not consistent with how we consider impairment analysis. And so they wanted to make sure that it was consistent, and that was some of the feedback that they received. So they did make that small change. And so useful life is the term that's going to be used there, a little bit different than what you will see if you look at the exposure draft. And therefore, as long as you are under common control, you can just use the useful life of it, even if the lease life is significantly shorter, like 1 year. In effect, you can end up with a lease that is not on the balance sheet because it's a 1-year lease, but you can have the amortization of the leasehold improvements over, say, 15 years for that useful life. So that was the reason why the 3 that voted no said, hey, we are going back to pre-842 where the lease is on the books and the leasehold improvement is on the books. And that's why they voted no. Totally valid. On the other hand, the 4 that voted in favor of it basically said it doesn't say you have to amortize to 0. So it's basically allowing you to have the same residual as you would have had if you were using the lease term. So they felt pretty confident that that was going to be just basically an equivalent outcome. So there were definitely different opinions here, but it was a 4-3 vote. What's interesting about issue 2 is that it also impacts public companies. Christine Bodison actually mentioned that she didn't, she voted no in part because she was concerned about the applicability to public companies because they weren't the ones who had brought up the issue. It was really private companies. However, for consistency of accounting purposes, they voted again 4-3 to allow this for all lessees that are under common control. So whether you're public, private, not-for-profit, it doesn't matter. It will change the leasehold improvement guidance for all entities. So I think that's very important. If you are obviously in the middle of something and you end, so let's say it's a 15 years and you end the lease after 7 and you terminate, basically as a result, that would be an adjustment through equity or net assets for a not-for-profit when you no longer control the use of the underlying asset. So it would transfer basically effectively back to the lessor at that point in time, which is equivalent to what the discussion was around dividends if you were to do the previous guidance under 840. So very exciting. We are going to have to wait. As always, a reminder, you cannot adopt a standard that has not been issued. That's a huge peer review issue for firms. So you have to wait until this gets issued. Again, late March is the expectation. The final ASU is going to be effective for fiscal years beginning after December 15 to 2023. But again, they're allowing early adoption. If you haven't issued under 842 yet, you can adopt in the implementation. So they're not going to prevent that. And they've actually given really nice transition guidance to assist with that as part of it. So definitely, we're waiting for the changes in the transition guidance, which is why I haven't included it here. But we are, expecting that really nice guidance that, hey, if you haven't adopted 842, you can adopt this with it, even though the effective date isn't until a little bit in the future. They also provide guidance if you had to, implement before they issued this ASU, what would be the transition options for you to implement this the following year. So very exciting. I'm glad this one has been voted out, but again, you cannot implement till we have a final standard. please, please, please do not have problems. We saw a lot of issues in revenue recognition after ASU 2020-05, delayed RevRec, and people adopted, issued financial statements that didn't have the adoption of Topic 606 in them because the delay had been voted for, but the delay hadn't been issued. So it's not based on the vote, it is based on the issuance. And so until we have a final ASU, you cannot apply this, but it is important to talk to your clients about if you're in public accounting, or for those of you who are in industry, to talk to your public accountant about how you're going to handle the issuance of the financial statements if you are in the process of implementing 842 and you have these related parties under common control lease arrangements. All right, that's a wrap for this week. Thank you guys so much. I look forward to seeing you on a future blog. Have a great day, guys. Bye-bye.